What is the legal framework around respect? Well, there are three things we need to talk about. The first is to clarify that the respect form isn't a legally binding document any more than DNA CPR is. The second is about the duty to consult about CPR recommendations more generally, and the third is about capacity legislation in general. So, in terms of whether respect is legally binding, lots of people ask about this, and it is not. What people don't understand is that DNA CPR isn't a legally binding document either. Both of them are pieces of information that can be used by a clinician in an emergency to make a best interest decision. And in that emergency, they're taking different information that is available to them in order to be able to give a treatment to a patient that will be in their best interests. And if they've got a beautifully documented respect form in front of them that tells them that certain treatments wouldn't be wanted or certain outcomes wouldn't be wanted, then that enables them to make an informed best interest decision. A good way of thinking about this is if a patient is choking, even if they have a respect form or a DNA CPR, you would still attempt to resuscitate them. Or if they were in theatre and they had a iatrogenic cause of their arrest, again, you would be ignoring their respect form or DNA CPR and you'd be making a best interest decision because there was a reversible cause for their arrest that you would therefore be treating in order to get them to an outcome they valued. So, respect forms not legally binding. The second thing is about the duty to consult on CPR decisions. So the duty to consult comes from two main case laws. The first of that is Janet Tracy. In her case, the DNA CPR notice was put in her notes without it being discussed with her, and the law found that this was a breach of her human rights because to not consult with her was to deprive her of the opportunity to ask questions about the recommendation and to deprive her of the opportunity to ask for a second opinion. So the law states you must discuss a CPR recommendation with the patient unless you think to do so would cause physiological or psychological harm. That is, of course, if that patient has capacity. If the patient lacks capacity, and we'll come back to capacity again in a second, then the second case that is relevant is that of Carl Winspear, who didn't have capacity. And following his case, the law states that where a patient lacks capacity, you must try and contact those close to the patient in order to be able to make an informed best interest decision. And you must try and contact those people close to the patient unless it is not practicable or appropriate to do so. Now, there are very few circumstances where it wouldn't be practicable or appropriate to contact someone. But an example that is often talked about is where you've tried to get hold of a relative or someone close to the patient, you've tried phoning them, there's no answer, then clearly it's not practicable to get hold of them. And you therefore need to document your efforts to do so. You need to then make your best interest decision and document it. And you also need to write in your ongoing plan that other people should continue to try to get hold of the person close to that patient in order that your recommendation can be reviewed. So the third step was capacity. So as you all know, capacity is decision specific. That is to say, it is not a general, this patient has capacity or doesn't. And in the respect process, as we've discussed, there are a lot of decisions that are being made. So you can't decide up front before you've started, in general, whether someone has capacity for these decisions, unless, for example, they have very advanced stages of dementia or have a learning disability or some other scenario which means they can't retain information. So in general, when you're assessing someone's capacity, you're assessing whether they can understand, retain, weigh the relevant information to making that particular decision. And so you will find that the capacity documentation is on the reverse side of the respect form, because as you're undertaking the respect process, you're evaluating whether that patient has capacity for the decisions that you are considering. If you think they didn't have capacity, you must document on the form why you didn't think they have capacity. And that might be, for example, that they couldn't understand, retain or weigh some of the information that you're talking about. And if the patient doesn't have capacity, then linking back to the last bit, you must make every effort possible to contact people close to that person in order to be able to make an informed best interest decision.